I'm hoping that the road to hell here is actually with good intentions, because everywhere there is a good intention. But again, as I said, that if either you don't back it up with infrastructure, then you have road to hell. Now, let us deal with the good intentions first. What are the good intentions? The good intention is they want to add certain time limits because they feel that the cases go on and on and on. So let's add time limits. I'll come to what is the impact of that. Second, in many provisions, they have added a minimum mandatory sentence. I'll come to the impact of that. Then, in many cases, they have felt the need to keep involved the parties in the criminal process, justice process. Like they want, for example, many of you, since this is a money-related group, will be concerned about check bouncing, right? 138, check bouncing, which clogs most of the criminal courts. Now they have introduced a provision that no court, no criminal court in such offences will even issue summons until it first hears the party. So even some of the judges are at sea as to what does this mean? That first you get the person to come to be heard before summons are issued. Obviously, the person will say, I don't believe. Very few people will come and say, I am guilty. So then that person in check bouncing or any criminal case, less than 7 years, the person will come, the accused will come and say what? Then once you have heard him, to what extent will you hear? What will you conduct a mini trial? And after you've done the mini trial, again, it's silent as to again how summons will go after this person has been heard. So your good intention was that, अरे पीठ पीछे कुछ होना नहीं चाहिए. Everyone should be heard. But now you've added this extra layer of where you're first, even before issuing summons process, you're going to first hear this person. Now, similarly, good intention that, some people feel that FIRs are just filed like this maliciously. So now they've added this provision that it is the discretion of the police. The police will do a preliminary inquiry. Of course, it says it's time bound within 14 days or whatever. They have to do a preliminary inquiry. But then again, it's given as a discretion. The Supreme Court had given a judgment in Lalita Kumari's case that every FIR has to be registered. And you know that a rich and powerful, a troll who is backed by a ruling party in the center or the state can register an FIR like this. A fact checker will run pillar to post, will have so much difficulty getting even an FIR registered. Forget justice, forget investigation, right? So, or an opposition party member will have such difficulty in getting an FIR registered against a ruling party person. So now they've added this, that there has to be the discretion is given to the police to consider this. So again, as I'm showing you, good intention, and it leads to road to hell, because again, you're giving so much discretion to the police. Similarly, again, a good intention, already it was there, a zero FIR. That anywhere, what is the objective? That if Sucheta has a snatching somewhere, her purse is snatched, let us say in Bandra, but then she finds out and her train ultimately stops, let us say in Thane, that she can go and register a case in Thane, though actually that happened in Bandra. So it's a good thing you're doing, right? But at the same time, you have not even provided in the law that that FIR will then be transferred to Bandra where actually it happened and Thane has nothing to do with it. Also, you talk about the bail application or remand application. The words uses nearest magistrate. Now, nearest where? Nearest to the person. So if Sucheta ji stays in let's say Worli, will she go over there? So there's a lot of good intention, but it is resulting in problems. Another good intention. Earlier, for example, if someone filed a case, investigation, and a charge sheet is filed, you could file a protest petition if you are the complainant, saying that, like I'm Arushi's father and mother, I am filing a protest petition that you have not made out the case. I have said you have to charge for section A, B, C, but you have only charged for section B, or you have filed a report saying no case is made out. I'm filing a protest petition. Conversely, the accused can say that, look, why have you charged me? Please discharge me, because you are saying I have done the offense of A, B, C, but look at the charge sheet, there's no document. Now they have added that any time within 60 days, a discharge application can be filed. Now, does this mean that, for example, when a sessions case is committed to sessions, I don't want to go into technicality. So a sessions case, the magistrate takes it and then commits it for trial to the sessions court. Now, will the sessions court be now sitting waiting for 60 days for that protest petition to come if it comes on the 60th day? And let us say it comes one day later and the person actually has a ground to say, I was caught, I had an accident, I fractured my legs, I was in a coma. There is no provision for condonation of delay. Earlier, all this was left to the judge in each case to decide. Now you're trying to be smart, you're trying to show that you're doing justice, you've added timelines. Again, good intention, road to hell. Another good intention, they have added that the charge has to be framed, again, timelines given within 30 days. Now look at this liquor scam in Delhi, or look at the scam unearthed by Sucheta ji last decade, like a stock market scam or a liquor scam, thousands of pages, so many witnesses, so many documents. How do you deal with these timelines? As I was saying in one show, that the elephant in the room is the infrastructure. You had the recent case where many of you, as a given money issues, you file consumer complaints, right? Many of you, and you've seen the state of consumer courts. Consumer courts dates are given 1 year later, 2 years later. Check bouncing cases dates are given 1 year later. And you are not increasing the infrastructure. You're not increasing the number of judges. And you are giving these deadlines and giving these lollipops, 30 days, 60 days, all this will be done. Good intention, road to hell. And again, no consequence provided. Again, I was discussing before we were recording this live with Sucheta ji that one of the things, look at this. They are saying that within 5 years of this law, every investigator will have on his phone a number of a forensic expert who will come rushing. You all see these American serials, CSI and all that. So the Pandu Havaldar will have this CSI who will come with the forensics to do the forensics at the scene of crime. Of course, the law very cleverly doesn't say in 5 years, if the state of Maharashtra doesn't do it, what happens then? Will the investigations be declared wrong? But now you've introduced this. Very good. Of course, there has to be technology and we have to take advantage of technology. But look at the existing state of police reform. Look at the police. What kind of equipments are you giving them? You all know. There was so much. There was a commission after that Mumbai attack, the terrorist attack, Ajmal Kasab and all. What kind of equipments the police had? You are not giving them, you are not empowering them, you are not freeing them from political interference, you are not giving them salary, you are not enabling them. And now you're adding all these extra burden that you have to, now they've provided for electronic recording of the scene of crime. And again, very strangely, the Pandu Havaldar you are expecting will record electronically scene of crime. But when it comes to the judicial confession, there you are saying it is optional, that you may record. So in the criminal procedure, many of this is done. I can go on and on, but I guess I have two more acts to do. I'll just wrap up on criminal procedure in another 2-3 minutes. Now, for example, there's a lot of confusion as to this issue of remand. They are very clever. There are judgments which have said that the police remand has to be done up to 15 days, the first 15 days. Thereafter, you can't ask for police remand. Police remand means when the accused is put in police custody. Now they have added that this 60 days or 90 days, depending on if the punishment is 10 years or 10 years or more than 10 years, any time during that period, you can ask for police remand. So the Mota Bhai in parliament was saying, or whatever, outside parliament, was clarifying that, हमने 15 दिन को period को, we have not increased the period, enhanced the period. 15 दिन ही है. But you see, you talk to a criminal law expert, a criminal practitioner, and he'll tell you the sting in the tail. The sting in the tail is this, that normally criminal practitioners wait for the first 15 days because they know after that the police can't do hanky-panky. Then the witness is the accused is in judicial custody, right? And then it is between the judge and the lawyer. The police have finished their investigation. Otherwise, why would they arrest in 15 days? Now, they don't have to take the entire 15 days remand, so they may take 3 days remand and keep shut. Moment a bail application will be filed, the police will say, Aji, I need another 1 day remand. So that bail application will then be dismissed by the judge. And he will say, okay, I'm dismissing your bail application because police wants a remand. Then it becomes a second bail application. You file after another 2 months, 3 months, 4 months. Again, police will say, oh, now I've got another angle. I want another 2 days remand. So now this is a weapon given to the police to deny you bail indefinitely till they exhaust that 15-day period. That means technically they can even take 2-day remands or 1-day remand. So every time your bail application comes, technically this can be done. Again, they have provided some good things also, like the accused has a right to be informed about the investigation. But as you know, in this case, when you are giving so much of discretion to the police, like it can call for your password, it can ask you to share your electronic stuff with you, with them, you are giving the police a lot of power. Especially if you see, now we talked about now let's talk about the Bhanasya, the penal code. Now in the penal code, now they have introduced all Makoka. Maharashtra was the first state which actually brought in organized crime into our criminal codes. Now Makoka and UAPA have all been brought into this, and I don't understand why they did that. Now UAPA definition of terrorism, identical definition is put into this penal code. And in the penal code, a discretion is given to police of certain rank to decide whether to proceed as the terrorist activity under UAPA or to deal with under the general law. Now, this kind of extreme discretion being given to the police, I don't know how this will pay out, in fact. And what was the reason when you have a special law, either you delete the special law. Now you are empowering certain states. Earlier, all these terror agencies, NIA, etc. There's a central angle also involved. There is a jostling of, as you know, in the Bhima Koregaon case, there was a jostling between the state and the center. The moment there was a change of government in Maharashtra, NIA took over that case. Anyway, less said the better. So now, again, even in the penal code, best intentions, road to hell. What is the best intention? They have now introduced the concept of mandatory punishment. So, for example, for child rape, gang rape, 20 years minimum punishment, mandatory punishment. For hit and run, 10 years minimum mandatory punishment. It sounds very good. But please understand, worldwide, as I was saying in one particular talk show, minimum mandatory sentences ensure there is zero conviction. As it is, our conviction rates are dismal. Now, with minimum mandatory sentence, judge, for example, a hit and run is so difficult to prove. You just had the most famous hit and run of this month in Maharashtra, in Bombay. So difficult to prove. In Delhi, a BMW became a truck when an influential person did a hit and run in Delhi. So it is only circumstantial evidence that you'll have. In these circumstances, if you give the judge a discretion on punishment, he may say, okay, look, I have only circumstantial evidence. Technically, I have to use the proof beyond reasonable doubt. So the judge normally massages this by saying, no, I have proved beyond reasonable doubt, but I'm giving you a little less punishment. So judge has done justice. At the end of the day, judge is also looking at doing justice. Now, and also remember that post-Nirbhaya, rape has been defined in a very wide term. And rightly so, but we have to be conscious of that. For example, digital rape, using your finger in a private genitalia of the woman is also rape. Right? Or attempt to do so is also rape. It may not be successful, but an attempt is made. Now, in these circumstances, the court also takes into consideration in convicting what kind of penalty I'll give. Now, if you're making it mandatory that 20 years has to be given, it will not happen. In this, as we were discussing, Shrutesha and I were discussing, proclamations were made that Rajdroho chala gaya hai. This is gone. This sedition is gone. But now they've brought it back, and with a vengeance. They've brought it back with a vengeance in which anything and everything which is spreading disaffection or against the interest of the unity and integrity of India, such language has been used. is punishable with grave and graver penalty. So again, what is the purpose? Even in the substantive law, now they've introduced deceit for marriage. There have been so many cases in India under the penal code where this issue is a gray area, breach of promise to marry. That they date, they have sex, and ultimately they break up, and then the woman will say that I had sex only because you promised to marry me. And there have been several rape prosecutions. And the courts have given the contours of this. Now you've added this thing, that deceit in marriage, deceit in having sex with the promise of marriage is now being made a crime. Where there was to be also, for example, 377. As you're aware, that 377 has been read down in Navtej's case, where only consensual sex between males has been made decriminalized. But what about a male rape? What about bestiality? That was still covered by 377. Now that has been, entire 377 lock, stock, barrel is gone. So male rape is gone now. So even in the substantive law, where they have made amendments, there are several issues which leave much to be desired. Of course, as I said, that there are positive things in the Saksha Adhiniyam, which there's before I go to that, one more thing which they have introduced, again in good intentions, but we don't know, the jury is still out. They have introduced the concept of community service as a method of punishment. So it is good, but again, please remember that unfortunately we don't have a even playing field. Many of you people, even middle class people, find it so difficult to hire lawyers and fight your cases. I know many of you can't afford. I can't afford to hire, let's say, a top senior like Harish Salveji and pay him crores. I can't do that. Or Mukul Rodgi. I'm taking these names not to be personal, but everyone knows these big names of these legal luminaries. Today, battling legal cases is so expensive for even an investor going to a court or a forum. There is no change made to legal aid, to public defenders, public prosecutors. In fact, they have taken away the right of the Delhi government to appoint as prosecutors and given it to the police, as in the Home Ministry, which will obviously, central government will act as per the advice of the Delhi police. So police and prosecution have now become one. The check on police was an independent prosecution. That is gone as far as Delhi is concerned. So even community service, I don't know, maybe a rich, influential minister's son will just write an essay as community service. And whereas a Dalit or a tribal or a deprived poor woman will not even have money to post bail. Of course, there are various other things which they have done, like they have allowed use of receipt of evidence electronically. Even remand hearings can be done through electronic means. So that and those changes have been done in the evidence law also, where they have expanded the scope and ambit of an expert witness to all matters, and then evidence being received electronically. But again, please relate this to the existing state. Please, I ask any of you, please go to the district court of nearest to you, just out of curiosity. I know no one wants to go to court out of curiosity. It's like saying go and visit a hospital. No one wants to go unless you are ill. But at times, it's very important for you to see the existing pathetic state of infrastructure. And you are expecting such high level of electronic usage. So which is why I said that, like Muhammad bin Tughlaq's path-breaking initiatives, like introducing a coin instead of gold and silver as currency, taking the capital to Daulatabad in the center of India to be insulated from the borders. They are very, very far-sighted and visionary ideas, but they're far ahead of their time. So here also, what you have done is you have made these laws where you have hardly had any effective consultation. You have not put a penny into the infrastructure in capacity building. And uh, you have introduced all these changes. Now, these changes again you have not given the country, the stakeholders, namely the lawyers, the police, the judges, to absorb and take it in. There was a request to defer this, but that was never done. And now these stakeholders who already had a trouble in implementing this will have difficulty in giving effect to this. And again, everywhere it's good intention, but again, road to hell. Good intention that you are making trial in absentia possible. Everyone says, oh, what about, the famous names are given, Narendra Modi, Vijay Mallya and all that. But yes, you do a trial in absentia, but will a trial in absentia meet the international standards of justice, which will permit an extradition from these countries, is an issue. Now you have provided for forfeiture of property for any involvement in any criminal activity, forfeiture of your property. So this whole concept of the state having this in cooperation with, of course, there is an oversight of the judiciary, but of course there have been complaints, as you know, where that oversight powers have not been properly used. So the issue is that whether we are actually creating a monster. Also, for example, the provisions like restriction on adjournments, timelines to decide mercy appeals. Of course, they have not given, they can't impose the punishment, they can't impose a timeline on the President of India. But certainly, they have now put in timelines before and after so that these mercy appeals, which go on pending for years, can be heard expeditiously. But this is not new. When it came to the amendment to the CPC, when it came to the amendment, introduction of the Commercial Courts Act, we have tried this. Stopping of adjournments. But do you think the adjournment culture, as you say in your films, Damini, Tariq, has that stopped? Of course, I have to take the fall as a lawyer. Often, and I have no shame in admitting it, often we lawyers are engaged just to secure a delay, just to secure an adjournment. Because the process is the punishment in India. The process is the punishment, and all of you know that. If you know that you file a criminal case, the complainant has to be there on every date of hearing. Every application has to be made for exemption. So many people don't. We as lawyers, in fact, someone actually long years ago banged my car. And then someone asked me that, why don't you want to file a criminal? And he was drunk. He was driving a motorbike and he was actually drunk. In fact, he was holding a bottle. I mean, the smoking gun was there. He was holding an alcohol bottle, and I was a young lawyer then. And I was asked that, will you file a criminal case against him? I said, God, no, because I know the criminal system. I will file a criminal case, and then for the next 20 years, I will be going there. I will be going and filing the every hearing because I'm a complainant. I have to be there. Process is the punishment. And there's a little lack of clarity, and I think I must end. Sorry, Sucheta, I've taken more time. I'm rambling on. A lawyer, given an unrestricted audience, can go on and on. So I'll just wrap up in the next 2 minutes. Now, just this little clarity your viewers should know. The fundamental principle of criminal law is that criminal law can't be retrospective. Okay, so you can't be punished under a law which was not a law when you committed allegedly committed the crime. So therefore, if any crime has been committed or alleged to have been committed before 1st July, midnight of 30th June, 1st July onwards, you will be tried under the substantive law of this Bharatiya Nyaya Samhita. Before that, under the IPC. You will not be tried under this new law, you'll be tried under the old law. However, the procedure will be the new law, Bhanasur, Bharatiya Nagarik Suraksha Adhiniyam, because procedural law need not can be retroactive, as in it can apply to a crime committed earlier. So we, as you know, a criminal case which goes on for 20 years, we are looking at a situation. Don't think that, oh, those criminal laws are over and now we have three new laws. We are now looking at a regime where you're going to have two different sets of laws operating, because these old cases, and there are thousands of cases which have been filed before this law, will continue all the way to the Supreme Court, and until the end will be governed by the old law, and then you will have this new law. So therefore, I feel that if decolonization was the purpose of the law, we have miserably failed. In fact, the colonial state, and many of your viewers will be surprised to know, the colonial state, which had the colonial police, was more conscious of citizens' rights than the so-called decolonization process. How, you may ask? Statements of the accused given in police custody were held inadmissible. Why was it held inadmissible? Under the Indian Evidence Act, British Raj ke zamane mein, it was held inadmissible because there was an understanding that the police would be, there was an element of coercion. Now you're introducing all these new laws since independence. I'm not blaming one particular government. Everyone has done that, where you're changing the burden of proof. Another thing the British Raj did, innocent until proven guilty. The whole principle of criminal law which the British introduces, that let 99 innocent men go scot-free, but not one innocent man should be hanged or prosecuted or found guilty. That was the principle. And that you have completely overturned. So as I'm saying, the colonial state was more concerned about the right of the Nagarik than the government which has brought in the Nagarik Suraksha Adhiniyam and the Bharatiya Nyaya Samhita, the Nyaya that you are giving. So therefore, as I was saying, that if you actually wanted justice, then you have to understand how creaking the criminal justice system is, how so many people don't get proper lawyers to defend them. People who are tribals, Dalits, women, middle class, even simple people who are upper middle class, small investors, your members, your viewers. There is no requirement made here that senior advocates, established lawyers will do community service by doing free legal aid, free cases for the poor, nothing. There is no provision of providing any form of police reform in ensuring the police is freed from political executive, that there is an independent check on whether the police is misusing the law. There's an ombudsman which governs the police, like in many foreign countries, that the police is actually insulated from the government, the politicians. But no political party will want to do that. So this is the real justice would have been in a decolonized India, where the center of your lawmaking is the justice to the aam admi, the common man,